We're live. Good morning. It is May 6th. Senate Judiciary for taking up House proposal of amendment. To be really long and complicated. That's 179. And we have pledge counsel here to give us the walkthrough.
Yes. Good morning. Eric Fitzpatrick with the Office of Legislative Counsel, here to walk the committee through, as the chair said, a very brief amendment that the House made to S-179, which is the Uniform Disclaimer of Property Interest Act. Does everybody have a copy of the as passed by Senate version? So if you look at page 4, it's in subsection C, lines 5 to 7. Now it's funny because you may recall that subsection, that's the one that permits a parent to disclaim on behalf of a minor. So that was in the bill as it passed the Senate. But there was a minor, that's funny. There's a small change that was made to this subsection on the Senate side as well. But when that change was made, there was a typo. And that typo is corrected in the House version. That's the only difference. So if you look at the word, line 6, the word minor, to define on behalf of the, so to the extent there's no material conflict of interest, a parent has defined it, so it's, and disclaim on behalf of the parent's minor, right? See that? So there's a missing word there, the word being child. So that's what that House amendment did. After the word minor, inserted the word child. So that would read, can disclaim on behalf of the parent's minor child if a guardian has not been or is not required to be appointed for this.
So would we then also want to add the word minor on line 7 at the end where it says appointed for the child? Should it be appointed for the minor child?
I think that's it's referring back to the previous sentence, to the previous clause. You're probably okay in that situation. But if you wanted a reason to make an amendment, you certainly could. Hang on. I don't think it's grammatically necessary in that case because it's preceding clause being referred back to the first time. In the first instance, it was the first time it appeared. So that was why it should be said. East should vote for it. But other than that, they agreed with the bill as passed the Senate in its entirety.
I'll be an adult and not recommend any other amendment.
I don't want to be that adult, but
just concur with this once we get a full committee.
Right.
I don't think there's going to be any issue with it. So, yeah. All right. Well, thank you.
Yeah, sure. Yeah. Like I said, it was pretty brief. I heard from the same witnesses you guys did it. I went through the same committees up there that went through down here, and didn't have any issues other than typo.
Excellent walkthrough, actually.
Yeah, happy to help.
So let's switch gears now to United Games.
Oh, sorry. Good morning, everybody. For the record, my name is Tim Dunn, Legislative Counsel. For you, you have S-298, what was called the Vote from the Rights Act. The House just passed a strike-all amendment. First thing they did was rename it to the Voter Protections Act. And For purposes of today's committee discussion, the chair would like me to just address the provisions with criminal penalties, or would you like me to kind of run through all the changes to the bill?
I think if you could run through all the changes that the House did to what we sent over.
Yes, very happy to. So for that purpose, I provided a bill overview that I think we would find useful. This summarizes the content of the bill, and then illustrates what has changed from Senate to the House. The House proposed changes in red here for this reference. So first thing, in addition to changing the title, it reorganizes the vote denial and resolution aspects of the bill, and instead of giving it its own chapter, it moves it to existing chapter 17 PSA, chapter 35. This the offenses against the purity of elections chapter, the effect of which would be that the Attorney General's office already has civil investigation authority under that chapter, and so the AG's office will then have the authority to investigate those claims of vote denial pollution. The text of those vote denial pollution sections has not changed since it left this chamber before, except the fact that it will now apply to not only race or color, but within membership in a language minority group, but also for individuals with disability. Say 45.1 spent, which is disability language is new, addressed, is maintained. The next part of the bill we have is the voter interference or interference of election section. And this committee took a look at House Bill 541, and then they took a look at the original parallel provisions in this bill, and I came in and talked about the each other, provide a side by side. To summarize, three. Let's see what House did first. So 298 had four distinct prohibitions with criminal penalties, and House Bill 541 just had one. Essentially, it's more generalized, but really did after much the same conduct. The House took out the four provisions and inserted the one provision. So the language will look very familiar. I can stop there and drill in if you like, or I'm just going to continue quickly and return. Continue through the rest of the change to return to that.
So are you, I guess, which page of the bill are you on?
So this will be the section 2, and 2B added 17. Let's see, 1975. So we'll find that. Okay, page 2 of the bill. And again, just this will also modify 1972 to remove to be made redundant to the language there. But the of substance law will be that second half of page 2 there. Interference with voters and election officials would read. No person shall intentionally or recklessly intimidate, threaten, or force, or attempt to do so any other person for the purpose of obstructing the right of the other person to vote or to vote as the other person chooses, or causing the other person to vote for or not to vote for any candidate for public office, a public question, and an election. Then also again, no person shall intentionally intimidate, threaten, or force, or attempt to do so a public servant, an election official, or a public employee for the purpose of obstructing the administration of the election. And we provide penalties provisions such as in violators shall be imprisoned not more than 2 years or fined not more than $2,000. So that again is the language coming over from page 541, replacing the four distinct offenses.
Is the penalty the same as what we sent them?
Pretty much. Let's see. There have been here and side by side that penalties are mostly the same. That is, shall be imprisoned not more than 2 years, not fined more than $2,000. There was, one of the four, it's actually half of one of the four. That was the 1934 section of interference in voting, in which there was a lesser penalty. That would be prison on 6 months or not fined more than $1,000 to vote on an effective voter. However, say that the other 4 or 5 variants which violation occurred are the same.
So are they? Did they? So I see in our draft that we had sent over, it's what was 2022 intimidation of election officers. Is that captured by what is described on lines 9 and 10 of page 2, where it says no person shall intentionally intimidate, threaten, or coerce?
Yes, I would say, let's see, no person shall intentionally recklessly intimidate, threaten, or force a public servant, an elected official, or a public employee for the purpose of obstructing the election. So, administration of elections. So, I'd say that intimidation of elected official, yes, largely the same conduct that's captured here. There's more specificity in the underlying bill versus the House's change. For example, they enumerate some of essentially examples of intimidation of election officers. And so bribery, intimidation, and threats, coercion, those are some what we have there. Or other means in violation of election law, hinder or prevent. So we have some here's synonymous language there, but it seems to yes, I would say it's very characterized in this actually overlapping content.
And they, and it's, but it doesn't look like the communication of false information to voters. That is that captured in any of their changes?
I would say it could simply fall under, let's see, recklessly intimidating, potentially and recklessly, that's through intimidation, threatening, coercion, and then seeking to obstruct the right to vote. The obstruction part, I think, that was quite nicely spreading false information. But is it being done? Let's see, intimidating, threatening, coercive manner. And it's kind of debatable, although it can also be read this for language in this is person counting temporally. I'd say, yeah, it has to be kind of couched in intimidation, threats, or coercion. So depends. That's why I often learn the answer, but I would say some conduct is lost. Capture some conduct.
And was there any? What was the rationale you were able to give the rationale?
I can't speak to that.
Did they have a rationale?
I was not present for all discussion of this. Apologize, I can't really call.
No, I was trying to figure out if who we can have from the House in a minute.
I would
Just explain.
recommend the reporter who, forget if it's Chair Byron or might be representative Waters Evans too.
I know in government operations, we've been having it recommend Waters Evans.
That's something.
And they took out all the like, civil rights of action for causes of action.
Yes. Yep. This language does not have a pseudo private right of action. The underlying bill had individuals who were aggrieved to seek their belief and attorney's fees. They don't like going to reply to board because it's really any other kind of damages or remedies. But this bill is enforced by the Attorney General's office for civil investigations, and then the criminal aspect, his office would be permitted enforce against it, but it does not speak to any sort of anything that looks like that by the manufacturer or interference of voters and elected officials.
And by any chance, do you know what witnesses they had to come in? Or actually, Emery, is there, you be able to check their witness list and see who might be able to have come in for this? Yeah. Thank you. So, okay, anything else in the walk division?
Just to quickly note that
That's something.
I probably asked this before, Tim, on page 3, line 14, where it says denial or abridgment of the right of the citizen of the United States to vote on race or color, a common membership in a language minority group. Because I live in Franklin County, right on the Canadian border, so we'll just refer to it as an example, someone who speaks French. Good. What does that mean exactly?
it's not defined here, and it's not, checked, it wasn't really defined in, prior versions or the Virginia or federal law what it's based on. I think there's essentially a common understanding that, it would mean somebody who's fluent in English. However, if a court were to, issue what is considered the right before the court, likely their approach to interpreting this, okay, is there a plain language meaning? Not, then they would then look elsewhere to federal usages or how the other states with similar state voting rights act may utilize it or have to find it elsewhere. I'm not sure if another state had to find it, but my review of Virginia materials and federal materials didn't really actually explicitly define that, but there's it's implied through the usage that's essentially likely the individuals who are not fluent in these. But
So for white on for interpretation that
yep, we have to find it.
Yeah, my understanding is that comes directly from federal law.
It's used in federal law. It's not.
Right. And do you have any sense of when it was first introduced as a concept in federal law?
Yeah, I believe it came in when the Federal Voting Rights Act was amended in the early 80s.
Okay, so it's been around and a term that's been used and understood for 40 plus years.
That's very good. And just quickly note that the provisions that were modified by the House have to do with local portions of the state for the checklist and certain affirmations taken necessary to share those, and then disclosure candidates, disclosures, candidates state, sorry, the disclosures for candidates who are running for state legislative and county offices, there are provisions for who has to close what between the ethics commission and the Secretary of State's office. And then I'll just note that there'll be a temporary suspension for 1 year of the enforcement penalties for any candidates who are state legislative office to look at the final financial disclosure. And then there was slight modification for the safety protection for candidates. That is that definition that was changed to the campaign finance rule to make explicit that expenditures may include burden or provision of monitoring systems that can be held in cybersecurity related and security versus just for intended protection.
Okay. I think we'll need to hear from, we'll need to get some more feedback from the House and some rationales to some of these changes. And it seems like there are a couple of significant changes. And so we'll hear something from that side, and perhaps another witness and figure out what the committee wants to do with the bill, and then we'll take it from there. Okay, thank you.
Thank you.
Or actually, I'm sorry, committee, any last questions on the 28? Okay.
See, I very more.
These are ready. So we're taking out 772 now. We have Lynch County.
Morning, for the record, Cameron Wood, Office of Legislative Counsel. Have a new draft of an amendment to 772. This is draft 3.1, based on the conversation that we were having last week, where I drafted up a few new provisions, at least primarily around the security deposits and the trespass language, but there were some other minor tweaks towards the bottom. So I'm coming into the Zoom meeting and I'll share my screen. The first change there on page 1, the reason that's highlighted, that's the reader assistance heading. And I think previously it said, termination of residential agreements. Yep, it's a termination of residential rental agreements. That's really amending a lot of things in the residential rental agreement chapter, not just termination. So I felt that that probably wasn't the best reflection of what that next section is. So I just changed it to residential rental agreements. The first changes in this bill, based on our previous conversation, is going to be on page 5. This is where, if you remember above, we're talking about this security deposits. If you remember the bill above, it adds in new language saying that a landlord cannot charge for or receive a security deposit exceeding an amount equal to 2 months' rent. And then there's some additional language in there about the landlord being required to give half of the security deposit back if there's a no-cause eviction, allowing a landlord to charge a separate security deposit for allowing pets, etc. But the key thing here is about adding in specifically that a landlord cannot charge more than 2 months' rent for a security deposit. Currently, there is a subsection in the security deposit section, subsection G, which allows a municipality to adopt an ordinance governing security deposits on dwellings. And I think the key language to focus in on is the language on lines 2 and 3, which says that the ordinance has to be supplemental to and not inconsistent with the minimum protections of the provisions of the section. Currently, there is no limit on security deposits. So you have some municipalities that have moved forward and enacted limits on what a landlord in that municipality can charge. Burlington is one. They have a limit, and it is less than 2 months' rent. It's 1 month's rent. And so the concern that's been raised was in adding into statute that a landlord can only charge 2 months' rent. What happens to these municipalities that have an ordinance that may be providing for less than that? So what this language is intended to do is to continue to allow the municipal ordinances to be enacted and to have force in effect going forward. And so a lot of this language is new. It's just kind of breaking up the section so it will, will work. So the key piece here is the language on sub A, lines 6 through 8. The ordinance may limit the amount a landlord may charge for a security deposit to an amount less than 2 months' rent as provided in subdivision A2 of the section. So simply allowing those municipal provisions to move forward and not be challenged.
Great.
The next change is going to be regarding trespass. Towards page 21.
Yes, sir. Before we go to that, I was looking at the changes on page 7 regarding the expedited hearing process. And I just wanted to share with the committee and for the public that, you know, we had a chairs meeting just yesterday regarding the end of session. Our committee basically has 48 hours left for the rest of our bills, and this is not a bill that I want to see die. And so, but there is clearly a lot of disagreement on different elements and the provisions within the expedited hearing process. We are creating a study for a housing docket to be created next session, and to get that information back next session. There's a part of me, divorced from the politics of all of this, which is, there's a part of me that believes that if we are going to entertain creating an expedited hearing process, which is quite new in this context, it would make sense that it is part of the housing docket and incorporated into that study. I don't think that with the language that we have right now that we're going to be able to implement something that we all that there's consensus on. I think that there's lingering question as to some of these elements and the information. So, look at the committee. I was talking this morning about moving the expedited hearing process into the study and having that be incorporated into that study, because we'll also have to determine, you know, what type of resources the judiciary will need if we're going to be creating a housing docket and creating this new expedited hearing process. And what will be looked at is, you know, some of the questions that we've been lingering on, such as whether or not the damage to the property is considered a factor, whether there should be an ongoing threat or if there should be a single instance of a threat, and also balancing, looking at the interests of both the tenant and the interests of the landlord, as well as other tenants in the property. So that will be, as well as the other timelines that brought up in this bill. So those will be incorporated into the study. It won't change the current law that we have related to this section. And that's something I want to be aware of. At a minimum, personally, I would like to make sure that at a minimum, the no trespass piece becomes law. And I think that that is one of the components that hone in on and make sure that we have consensus on. And yeah, just want to make that announcement. So any questions? Please carry on.
Good segue into pulling up the most recent version of that language. So as I mentioned, we're going to be on page 21, moving into the sections related to trespass. First change here on line 3, a change in the word that was raised, the concerns raised by Senator Baruth about using the term overrule. So that's been changed to override. And I've consulted with Eric Fitzpatrick, and this term is acceptable to accomplish what the sections are intended to accomplish. Then we get to the new language on page 22 to address some of the discussion that we were having last week. So the first piece is adding in a new subdivision D there on lines 5 through 7. As we talked about, this new trespass subsection would allow a landlord to issue a no trespass order against a tenant's guests, their invitees or licensees. And we talked about whether or not the landlord should be allowed to, under this section, whether you want to have in here the ability for the landlord to issue that no trespass order if the person had previously been ejected from the property. And so this is what the subsection D is intended to cover. The landlord can issue that no trespass if the invitee or licensee has previously been ejected from the dwelling unit under 12 VSA chapter 169 due to a termination of a rental agreement under 9 VSA 4467B. So there would have to be the ejectment. The person would have previously been in a dwelling unit. They've been ejected, but it's only based on terminations that were brought under 4467B, which are the terminations because the individual has violated material terms of the rental agreements, or because the individual, their current law, has engaged in criminal activity, illegal drug activity, or acts of violence, which threaten other people. So you're limiting to those. Now, I will say there is, a little bit of, the courts may have to sort through, because a landlord can bring an ejectment based on multiple different terminations. The landlord can issue a termination notice under different sections of the termination, section 4467. So it's going to depend on the circumstances. But my understanding from the discussion was you wanted to limit the ability to issue these no trespasses to those circumstances, because somebody may be ejected for a no cause eviction. And this was a point of discussion that you all were having last week about how it stands. So I'll keep going, and then unless questions come up, you have the subsection 2 here, which talks about individualized consent being required. It's consent under the subdivision A1. If you remember, the landlord can issue the no trespass if the tenant consents to the order. And there was discussion about if a landlord could put some sort of blanket term in a rental agreement that would kind of make the tenant pre-consent, if you will, to any order against trespass of their guests in the future. And I made comments that, there could be arguments that a provision like that could violate implied, covenants of good faith in contracting, or a court could determine that those provisions are unconscionable and violations of public policy. That's an open question. I was just making the point that that argument could be made. And we discussed that if you want that to be the policy, that means you have to have individual review, then it's probably best to put something in the statute. So that's what subdivision 2 here, starting on line 8, would cover. Consent required under 1A shall be provided on an individualized basis, and it shall be against the public policy of the state for a tenant to provide blanket consent under subdivision 1A to all invitees or licensees. And any provision of a rental agreement that provides blanket consent from a tenant shall be void and enforceable. And then you move on to the subsection 3. There was discussion about how long should the no trespass order be in effect. And you all talked about having a 1-year applicability period. So that's what subdivision 3 is intended to address. An order against trespass served under the section shall be enforceable for 1 year from the date the order being served. The order may be renewed for subsequent 1-year periods if the landlord causes to be served a new order. So those are the provisions that we were discussing last week. And that's what I drafted up. I ran it by Eric Patrick, and he reviewed the language and was comfortable with what you have here. So happy to answer any questions that you will have about these pieces. But
Definitely good, but the language that is great. Okay.
okay. The only other changes that I've made, and apologies here on page 23, I've simply included the definition of premises, because I mentioned above that the invitee has been ejected, since the invitee has been ejected from a dwelling unit on the premises. So the reason I think the reason that can be applicable is if I've ejected you from some other premise that has no relation to where you've been invited as a guest, there's a question of whether you want, how you want that to play. And so what I've drafted here is the invitee or licensee has previously been ejected from the dwelling unit on the premises. You can add in the premises subject to the no trespass order if you want to ensure that that is, absolutely certain. But that's why I had to add the definition of premises. Because this is defined as the dwelling units, its appurtenances, its buildings, grounds, areas. The dwelling unit is the dwelling unit within the overall building premises. So the only other changes I've made here are towards the bottom, and this gives me an opportunity to kind of circle back, Mr. Chair, for things that you were commenting on in the study. This is the study language that I had penciled out in a previous version. And I've just made consistent throughout the language that this would be looking at creating a dedicated housing docket. I think it's a dedicated housing court. And then talking with the judiciary team, there was some recommendation about using housing docket. And so I've just made that consistent and see throughout those subdivisions. But here is where I can add language in saying that as part of this study, it needs to be reviewed. Could this housing docket, what's the feasibility of the housing docket being able to address the expedited hearings that you have introduced in this bill, and whether those timeframes could be met? How to incorporate the current expedited hearing processes that are in statute into this new housing docket? And Mr. Chair, you mentioned balancing the interests of the landlords and tenants and the tenants, et cetera. So I would add some of that into this section here.
And it would also look at balance or at the other proposed changes to the timeline, the notice timelines that we stretch.
Yes, sir. I think I would want to work with the language, but something to the effect of, ensuring that as they're providing you a report of what this housing docket would look like and what resources would be necessary to ensure, the administration of the docket, looking at not what the current law is, but looking at what the proposals are in H772 with the notice timeframes that are built and how the bill came over with the House drafted that way. So that's a review would be looking at those timelines and not the current statutory timelines.
Maybe again, questions or comments?
In reference to the housing court study, I see where it says the court administrator shall submit. Are there other members on this particular study? Or just the court secretary's office?
It's not drafted as a study, so it's just drafted as a report from the judiciary. And I was kind of stealing some language from previous types of reports that you had done. I think it's intended to be a study in the sense of, reviewing how this would work. They need to study that, but it wouldn't be a committee of individuals. We can draft it that way if that's the direction that you want to go. This was just something I had, like I said previously, I think I had based this off a study that you had done previously regarding creating drug-related court dockets.
The reason I was asking is because it says housing court study.
Yes, sir. Yes, sir. But for example, if you could require them to engage with certain stakeholder groups in developing the information, if that was something that you felt would be necessary. Up to you how expansive you want to get with the requirement.
Yeah, I think since because there's two sides to it. I think that the judiciary will would likely say this is a policy decision, and if we are asking them to figure out how to create an expedited hearing process in this new housing docket, and that they shall consider how to make the hearing or how to have it be a much shorter time frame from the notice to the ejectment, whether it's 7 days or 14 days, as we were describing earlier in the bill. I don't think they're going to come back and say, we think it's a better idea to just not do it at all. Right. I don't think they would say that. I think that they would likely come in and say, but we want the judiciary to be able to do this in 14 days. Here are the resources we need, and I think that would more or less be it. I guess on the other hand, the question would be the taking into consideration of the elements like damage to the property. With that one, I think they would just come back and say that's a policy decision. If you wanted to involve damage to the property, then that's the legislature's choice. So that's all to say, I'm not quite sure if we should or shouldn't add any other stakeholders in this. Yeah, that's all. Maybe if you have any thoughts on this.
And one point I will mention, before you go to the discussion, one thing that the court could look at though is to say, if we're going to create a housing docket, here's what the resources we need, and here's the structure that it could take. Then you obviously have the stakeholders who have to engage in that court process in order to accomplish, what they're trying to do, the ejectment, the defense of the ejectment, et cetera. So you may want feedback from those stakeholders to say, court comes in and says, here's the housing docket that we propose, here's the resources that we need, here's the timeframes that could exist in order to accomplish the policy goals that you've outlined for us to accomplish. And do you want those stakeholders to engage with the court during this review process to say that does work for us, that doesn't work for us, et cetera. Open to you all, it's just a suggestion that you can take as part of your discussion.
So what exactly would that look like in the language?
I think
Or generally, what would it look like?
I think we could draft something up to say that the court shall engage with the relevant stakeholders. The court may come back and say, we don't like a very vague term like that. Tell us very specifically who you want to engage with, but I could imagine you drafting something up or what it says in developing this housing board docket, this housing board docket sits down, you need to engage with the stakeholders for feedback and provide that feedback as part of the report in writing to also have it. I'm not telling you need to do that. I'm saying it's something that I could imagine drafting up and requiring you to do.
And thoughts?
I'm comfortable with the way it reads. The reason for that is because we're asking the court to do this feasibility study. And when they come back and may not be useful for this body, but we're comfortable on implementing it. If that, then they can move forward. Like, they say, okay, so now this is what they need, and this is what they tell us they need. Where do we go from here? And then there's potential or possibility of looking at bringing other stakeholders into the picture. But let's see what they need for this formal and roll on there. Like it.
Yeah, and then following that too, when they come back next year, whoever's sitting in these seats, they can hear from the stakeholders. Because, no matter what, it's almost impossible to capture every single stakeholder in the creation of a study. Somebody will feel left out. So, yeah, all right. So I'm good with that. Is everybody?
I don't necessarily have a strong opinion one way or the other on this, but I wonder if it would make sense in our consideration of including stakeholders in this discussion to ask some of the stakeholders if they feel strongly that they should be included. The only thing that sort of, so I don't really actually have a strong opinion, but I wonder, if the court comes forward and says this is what we would propose, and then we bring the stakeholders in and they're like, no, that doesn't work for us. Do we start back at ground zero saying, okay, court, go back and propose something different? Do you know what I mean?
I think so. However, I think my counterpoint would be that, the courts, or rather the judiciary knows what works best for the judiciary branch and how the courts operate. And it's certainly not uncommon for any party to say, we don't like how the court is doing X, Y, and Z. And then the court may come back and say, well, that's how we have to do it, or that's what we have the resources for. And if you haven't, then you have to talk to the legislature. So that's my initial thought, but any other thoughts on adding stakeholders or leaving this to the court to figure out.
I would.
Yes, I think the judiciary would know best. I'm sure they would ask for input where needed, right?
And we, or whoever is here next year will have the opportunity to also work with those stakeholders. Figure it out. Thank you. Anything else on this bill?
I have not drafted up new language. There were obviously a few other points of discussion that you were having. Mr. Jerry, you mentioned that's why I kept the language highlighted about the specific termination, criminal activity, damage to the et cetera. But if we're bringing that out, incorporate that into the study at this point, I don't know if there's any other lingering questions that I recall from the conversations that I've been in the room, but.
Yeah, I was gonna say, it seems like the issues that are of primary contention or disagreement are going to be incorporated into the study. Okay, so, and would you be able to come tomorrow with that draft? Yes. And then my hope would be that we vote it out tomorrow, and the other committee their time as well to look at it. Anything else on this bill? Everyone speaking. Great. Okay, thank you very much.
Yes, sir. I'll be back tomorrow with a draft 4.1. I'm sorry. There was one other question that was brought up very quickly. You were discussing when does a guest become a tenant? And so just quickly, I went and I was, just penciling out what, is the kind of guidance out there that exists. I actually found, I will give them a shout out there in the room. There was, I thought, a pretty good guide pulled together by Vermont Legal Aid and Legal Services of Vermont, kind of identifying for individuals how this area of the law works. It's really my understanding here is going to be a fact-specific scenario. There's not a bright line rule that says you stay in a dwelling unit for this number of days, you automatically become a resident of that location. It's going to be dependent on what the relationship is between the guest and the individual who has legal possession, rights of possession of that unit. What are the agreements that they have? Has the person authorized that person to move in and live there? They now have a verbal agreement that allows that person to live in that unit. You've given the person keys to the unit, they come and go as they want. Those are going to be kind of factors that a court would look at in making a determination of whether somebody is now a tenant of that dwelling unit. So it's really just going to depend on the facts. Have you told that person, hey, you can live here, but you can only stay here for this number of days, and then you need to leave? During the stay, has the person continued to, put the person on notice that you're just a guest and, you are here with my permission? It's really going to be a fact-specific scenario as to whether or not the agreement between the parties has given that individual guest tenant status, is how I would call it, and the right to live in that unit. So I just wanted to mention that. I'd be happy to send this to you. You can find it online if you want to. I thought it was pretty helpful.
Yeah, if you don't mind, sending that would be great.
But that was the other question that came up that I meant to bring up this one.
Cool. All right, so we can take a break. We have Michelle coming in soonish, so let's take a break for 10 minutes. Back. Thanks.